My name is Rosalind Holman and I reside in Darlington, South Carolina. The purpose of this video is to promote my quest for procedural due process in our American court system, while alerting others to the rampant collaborative corruption and cover-up instituted among judges and other government officials within America's judicial system and government agencies. Although infringement upon my constitutional rights by various United States judges and other court officials has been ongoing since 2006, this video will primarily focus on the most recent deprivations implemented by the United States District Court for the Eastern District of Pennsylvania. The deprivation implemented by this court are continuing on cover-up of prior deprivations implemented by judges in other United States courts. Accordingly, prior deprivations are referenced. With willful intent to deprive me of due process, District Judge Joe Slomsky issued the following void order. On page 1 of Judge Joe Slomsky's self-confirmed void order, he falsely alleged considering my brief that supported my Rule 60B motion. Contrarily, his order failed to acknowledge or address the irrefutable allegations explicitly detailed in my 10-page brief. Judge Slomsky also failed to acknowledge or address the prior void orders and judgment that is sought to have vacated. The prior board orders and judgment, the sole purpose of the Rule 60B motion, were submitted as evidential exhibits to support the motion. This alleged order consists of 3 one-line numerical statements. In Statement 1 on page 1, Judge Slomsky asserts, plaintiff motion document number 1 is denied. Then he links this statement to a lengthy footnote. Within this footnote, Judge Slomsky merely cites Rule 60B stipulations. Then he commences his deceptive summation of prior cases upon which my Rule 60B motion is founded. In Statement 2 on page 2, completely disregarding my Rule 60B motion, its supporting exhibits and Rule 60B provisions, Judge Slomsky merely asserts this action is dismissed with prejudice. And in Statement 3, Judge Slomsky asserts the clerk of the court shall close the above captured matter for statistical purposes. Judge Slomsky's signature is below the third statement. Then he continues his deceptive footnote summation that began on page 1. Although my Rule 60B motion cover letter and my motion explicitly petitioned this court to set aside a non-monetary void judgment and enforce my title right to a trial by jury, in the third full paragraph of Judge Slomsky's footnote, he falsely alleged that my motion was improperly filed and registered under Title 28, Section 1963 for the recovery of money or property. In the fourth paragraph, Judge Slomsky deceptively asserts that plaintiff acknowledges that she seeks to set aside a non-monetary judgment rather than money or property as required under Section 1963. Therefore, this court does not have subject matter jurisdiction over plaintiff Rule 60B motion. Note that in this paragraph, Judge Slomsky asserts that the court does not have subject matter jurisdiction over my Rule 60B motion. Subsequent to his first statement in which he denied my Rule 60B motion, and his second statement in which he dismissed my action with prejudice. In paragraph 5, Judge Slomsky asserts that even if the court had subject matter jurisdiction over plaintiff's motion, her motion would be denied. Then in paragraph 6, the last paragraph, he states, therefore the court will deny plaintiff's motion to vacate a void judgment pursuant to Rule 60B. Judge Slomsky's March 14, 2013 order failed to cite or adjudicate the judgment corresponding to my Rule 60B motion, for which a vacate order was sought. Therefore, he failed to apply Rule 60B to the motion, and his narrative pursuant to prior proceedings is verifiably unfounded. Within this order, completely disregarding the substance of my motion and the corresponding rule, Rule 60B, Judge Slomsky simultaneously denied my Rule 60B motion, asserted lack of subject matter jurisdiction, then reiterated his denial of the motion. Yet Judge Slomsky adamantly maintains that my Rule 60B motion was properly denied and he refuses to vacate this order. This void, contradictory document, issued as an order, allegedly derived from the following Rule 60B motion supporting brief. My Rule 60B motion cover letter, dated May 11, 2011, explicitly states that I filed a Rule 60B motion in the Eastern District Court of Pennsylvania, seeking an order to vacate the void judgment rendered by the South Carolina District Court to effect the enforcement of my entitled right to present my case in a trial by a jury as demanded in my Title VII civil action. This brief supports my Rule 60B motion. Petition the District Court of Eastern Pennsylvania to vacate the District Court of South Carolina's void judgment, subsequent to South Carolina District Court unexplained injustice by relentless denial of my Rule 60B motion to vacate its willful and self-established void orders and judgments. Although my Rule 60B motion supporting 10-page brief consists of explicit allegations that were affirmatively supported by cross-references to evidence on record and hard copy exhibits extracted from relevant case files, the case record will confirm that Judge Slomsky denied this motion with prejudice without applying Rule 56 and without addressing any of the allegations or supporting exhibits, and to a greater extent, he completely disregarded the District Court of South Carolina's void judgment upon which the Rule 60B motion is founded, and brought before the District Court of Eastern Pennsylvania for adjudication and vacation. Pages 9 and 10 of this brief list and describe Exhibits A1 through H that consist of all prior void orders and judgments submitted to support the Rule 60B motion. Exhibit A1 is the void order entered by South Carolina District Court Judge Terry L. Wooten, pursuant to my job discrimination civil action under Title VII of the Civil Rights Act of 1964. On August 23, 2007, Judge Wooten filed this insufficient self-established mock document, willfully denying me due process and a trial by jury. Judge Wooten entered into a conspiracy with the defendant's attorney and willfully violated summary judgment rule 56 of the Federal Rules of Civil Procedure to dismiss my meritorious Title VII civil action. Evidence on record. My cross motion for summary judgment. My evidence-based opposition to the defendant's Rule 56 motion. My irrefutable objections to the magistrate judge's report and recommendation. And most importantly, the document filed by the defendant on December 18, 2006 that acknowledged the existence of genuine issues of material fact were all disregarded by Judge Wooten. This admission by the defendant, see Exhibit A3, precluded grant of summary judgment under Rule 56. Additionally, acknowledgement and provisions prescribed under Title VII, the statute governing my civil action, were omitted from this alleged order. Although Judge Wooten granted defendant's prejudice motion, denied my cross motion, and dismissed my civil action under Rule 56, his alleged order is devoid of Rule 56 and its mandatory stipulations. Judge Wooten's alleged order is also without signature. To date, all succeeding orders, judgments, appeals, petitions, civil actions, judicial misconduct complaints, and motions are founded on this fraudulent document and its corresponding judgment, Exhibit A2, issued by Judge Wooten as an order in my Title VII civil action. Exhibit A2 is Judge Wooten's insufficient unsigned mock judgment pursuant to his fraudulent order. Exhibit A1, on which all succeeding civil actions and judicial proceedings are founded. As confirmed by the corresponding case record, Judge Wooten filed his mock judgment with willful intent to deprive me of my right to due process and my right to a trial by jury in my meritorious Title VII civil action. Exhibit A3 is defendant's opposition to my cross motion for summary judgment. This document, docket entry 61, filed on December 18, 2006, affirmatively nullifies defendant's preceding perjury Rule 56 motion, filed on November 14, 2006, docket entry 55. Defendant's opposition asserts that there are genuine issues of material fact that preclude grant of summary judgment for the plaintiff. Contrarily, under Rule 56 of the Federal Rules of Civil Procedure, there can be no genuine disputed issues of material facts by either party. This admission precluded grant of summary judgment for the defendant and me. As confirmed by the case record, my cross motion and disputed issues were completely disregarded. The motion for summary judgment was a collaborated scheme devised by Judge Wooten and the defendant to dismiss my Title VII civil action. Accordingly, Judge Wooten willfully disregarded the defendant's unintentional admission and granted the defendant's perjurious summary judgment motion. See Exhibit A1. Exhibit A4 is the void judgment of the United States Court of Appeals for the Fourth Circuit. Although the Fourth Circuit panel judges, Diana Gibbon Motz, Roger L. Gregory, and Allison K. Duncan, were all aware that Judge Wooten's order and judgment pursuant to Title VII and Summary Judgment Rule 56 were void, they failed to remand the case back to the lower court for lawful adjudication. Instead, they joined in the conspiracy, and without addressing my evidence-based informal brief or my subsequent petition for review, and without performing the required review of the case record, by unpublished opinion, the Fourth Circuit panel judges issued this void judgment, willfully affirming Judge Wooten's void judgment. I acquired an insight of laws pursuant to void orders and judgments subsequent to filing this unnecessary appeal. Subsequent to a collaborative conspiracy to implement the deprivation of my due process rights and denial of a trial by jury, as irrefutably substantiated by Exhibits A1 through A4, I filed a civil action for deprivation of rights under color of law pursuant to Title 42, Section 1983, in which I name all 9 perpetrators as defendants. As established by the following exhibits and other supporting data, I was deprived of due process in this civil action. District Judge Slomsky March 14, 2013 void order is founded on my Rule 60B motion to vacate the void judgment entered in this civil action. Exhibit B1 is Magistrate Judge Joseph McCrory, first report and recommendation. Although the case record irrefutably establishes the willful and malicious acts of the 5 defendant judges named in my deprivation of civil rights action, on pages 5 and 6, Judge McCrory falsely asserts entitlement to judicial immunity and accordingly recommended dismissal of all claims against these judges. Exhibit B2 is my objections to Magistrate Judge McCrory's report and recommendation pursuant to my deprivation of rights civil action. The 5 defendant judges named in my civil action did not make judicial or administrative errors. They conspired and engaged in willful malicious criminal acts outside the judicial authority as confirmed by the case record. Accordingly, these 5 judges are not entitled to judicial immunity as falsely cited in Judge McCrory's report and recommendation. Pages 6 through 9 refute the distorted background section of his report and explicitly detail the willful torts against my constitutional rights that were implemented under color of law by the 5 defendant judges named in my deprivation of rights civil action. Pages 9 and 10 reiterates the extent of the 5 defendant judges' violation of civil rules and federal statutes to willfully deprive me of due process and a trial by jury. Consequently, judicial immunity cannot be invoked, and Judge McCrory's report and recommendation are unfounded. Exhibit C is District Judge C. Westinghouse's first void order that is contrary to Magistrate Judge McCrory's report and recommendation and my objections. On page 3, Judge House falsely alleged that my objection consists of previous arguments that were considered and rejected by the magistrate judge. Contrarily, the magistrate judge's arguments, Exhibit B1, for judicial immunity was refuted by my evidence-based arguments, Exhibit B2, that established that based on the 5 defendant judges' willful and malicious violation of my constitutional rights, they were not entitled to judicial immunity. Judge House did not adopt the magistrate judge's report and recommendation as falsely alleged in this order. He completely disregarded the magistrate judge's report and recommendation that proclaimed entitlement to judicial immunity. He also completely disregarded my explicit objections, and without any justification, Judge Howe willfully dismissed my meritorious deprivation of rights action against the 5 defendant judges. Exhibit D is District Judge House's second willful void order. Under the judicial authority of Judges House and McCrory, the 4 co-conspirators named as defendants in my deprivation of rights civil action filed purchase dismissal motions under Rule 12 of the Federal Rules of Civil Procedure. In this purchase void order, disregarding Civil Action Statute Title 42, Section 1983, evidence on record, and my irrefutable objections to the corresponding report and recommendation, Judge House dismissed my civil action against the 4 co-conspirators who participated in the deprivation of my constitutional rights. See Exhibits A3, B2, and F. Through the manipulation and violation of Rule 12 of the Federal Rules of Civil Procedure, Judge C. Westinghouse filed a second willful void order, falsely asserting that I failed to state a claim upon which relief can be granted. Accordingly, he granted the 4 co-defendants Prejudice Rule 12 motions and illegally dismissed my meritorious civil action against these defendants. Exhibit E is District Judge C. Westinghouse's unsigned void judgment, in which he dismissed my meritorious deprivation of rights civil action against the 9 defendants who, in a collaborated conspiracy, deprived me of due process and a trial by jury. A review of the case record will confirm that this judgment and its corresponding orders submitted with my Rule 60B motion as Exhibit C and D constitute collaborated perjury brought upon the court by the court, violation of Rule 12B of the Federal Rules of Civil Procedure, and obstruction of my right to utilize Statute 42 of the United States Code Section 1983, enacted by Congress as a remedy for civil rights violations committed under color of law. The case record will also confirm that District Judge C. Westinghouse and Magistrate Judge Joseph McCrory are perpetrators who exceeded their judicial authority. The willful malicious acts of these judges deprived me of constitutional rights actionable under Statute 42 of the United States Code, Section 1983, and other criminal statutes. Exhibit F is my Rule 60B4 and B6 motion, addressed to Chief Judge David C. Norton, petitioning the court for relief from Judge House void judgment. Exhibit E. All facts and arguments herein are reference to irrefutable supporting evidence on record. Pages 2 and 3 of this motion dispute Judge House's unsupported judgment, dismissing my meritorious deprivation of rights civil action without addressing or disproving my deprivation allegations. Judge House's orders completely disregarded Statute 42 of the United States Code, Section 1983, under which the civil action was filed. Judge House lost subject matter jurisdiction based on his exclusion of the statute governing the civil action, his entry of orders controverted by the case record, his deprivation of due process, and his will for participation in other malicious acts that exceeded his judicial authority. Page 3 also divulged the fact that although Judge House's February 24 order, docket entry 37-1, alleged considering my objection and adopting the magistrate judge's report and recommendation, his order is devoid of my objection and the magistrate judge's declaration for entitlement to judicial immunity for the 5 defendant judges. Page 4 divulged the fact that Judge House's order is based on prior void orders and judgment upon which my deprivation of rights civil action is founded and from which I sought relief. See Exhibits A1 through A4. Page 4 also divulged Judge House's willful fraud upon the court. Page 5 divulged the fact that my Rule 60B4 and B6 motion petitioned the court to vacate its void orders and judgments, Exhibit C, D, and E, was completely disregarded. Page 5 also divulged the fact that Chief Judge David C. Norton denied my motion and supporting affidavits for the recusal and disqualification of District Judge C. Westinghouse and Magistrate Judge Joseph R. McCrory. Page 6 continued the discussion of denial of motion for recusal and disqualification of Judge House and McCrory. Page 6 also began the discussion of Judge House's deprivation of my procedural due process right and his loss of subject matter jurisdiction. Page 7 divulges Judge House's continued entry of void orders subsequent to loss of subject matter jurisdiction. Page 8 divulges Judge House's attempt to assert jurisdiction where there is none. Page 9 discusses the orders and judgments, Exhibit A1 through A4, brought forward from my Title VII job discrimination civil action, from which I sought relief. Page 10 divulges the Court of Appeals for the Fourth Circuit, 3 co-defendant judges ruled for void order, illegally affirming the district court's void order. Page 11 divulges the fact that my 2 Rule 60B motions petitioning the court to vacate all void orders and judgments that it entered into the record, in addition to vacating prior void orders and judgments upon which my deprivation of rights civil action is founded, were completely ignored. Page 11 also discusses the court's grouping and incorrect filing of my descriptive label exhibits on the case docket. The top of page 12 continues the discussion from page 11. The bottom of page 12 summarizes that all orders and judgments on record constitute a deprivation of due process. Accordingly, I petition the court to vacate all void orders and judgments and to adjudicate my deprivation of rights civil action on its merit. Exhibit G is Chief Judge David C. Norton's denial of my Rule 60B motion, my Exhibit F. Petition the court to vacate all void orders and judgment in the case record. On page 1, the background section of Chief Judge Norton's order cites the constitutional deprivation and federal statute violations alleged in my defamation of rights civil action. However, Chief Judge Norton failed to mention the fact that all allegations are affirmatively substantiated by evidence in the corresponding case record. In the first two paragraphs on page 2, Chief Judge Norton falsely alleges that Judge House adopted the magistrate judge's recommendation for dismissal of claims against the 5 defendant judges based on judicial immunity. Contrarily, there are no statements pertaining to judicial immunity in Judge House's order. Docket entry 37-1, my Exhibit C. In fact, Judge House's order gave no reason for the dismissal of my deprivation of right claims against the 5 judges. Chief Judge Norton also alleged that Judge House adopted the magistrate judge's recommendation for dismissal of all claims against the other 4 co-defendants. The explicit irrefutable allegations in my complaint, as well as my evidence-based objections to the magistrate judge's reports and recommendations, my Exhibit B2, were unaddressed and therefore completely disregarded. Beginning with paragraph 3 on page 2 and continuing on page 3, Chief Judge Norton lists but failed to address and or refute my 16 evidence-based allegations that supported my Rule 60B motion. In the first complete paragraph on page 3, Chief Judge Norton mentioned that on November 12, 2010, the defendant filed a response to my opposition to his Prejudice Rule 56 motion for summary judgment. However, Chief Judge Norton failed to divulge that subsequent to this response, on December 18, the defendant filed another response, docket entry 61, my Exhibit A3, that precluded grant of summary judgment under Rule 56. On page 4, the third paragraph of Chief Judge Norton's discussion asserts that an order is void under Rule 60B only if the court rendering the decision lack personal or subject matter jurisdiction or act in a manner inconsistent with due process of law. Judge Norton failed to disclose that Title VII of the Civil Rights Act governing statute and its provisions pursuant to my initial job discrimination civil action proceedings, nor summary judgment Rule 56 and its prescribed stipulations, under which motions were granted and denied, were mentioned in the initial court's order and judgment. See my Exhibit A1 through A3. Paragraph 2 on page 5. Chief Judge Norton forcefully asserts that my argument that the court lacked personal and subject matter jurisdiction over the case is without merit. Contrarily, he is fully aware that the court's failure to cite and apply deprivation of rights governing statute, Title 42 U.S. Code Section 1983, and Rule 56B, pursuant to the civil action, rendered the order and judgment void, constitute inconsistency with due process of law, and fraud upon the court by the court, and accordingly loss of personal and subject matter jurisdiction. Chief Judge Norton is fully aware that no judge or court can validate a void order or judgment, yet he opts to uphold the willful void orders and judgment of the magistrate and district judges under his authority, by perjurously denying my meritorious Rule 60B motion. More importantly, Chief Judge Norton is aware that the unsupported fabrication in this order are affirmatively controverted by evidence on record. Disregarding the fact that evidence on record, particularly the judge's controverted filings, irrefutably confirms that all reports and recommendations, orders, and judgments that either dismiss or deny my meritorious civil actions and corresponding motions. Page 6 of Judge Norton's order falsely states that plaintiff offered no evidence to support her contention that she was denied due process. And although in my complaint I demand it was denied a jury trial, Judge Norton also falsely states that plaintiff does not claim she was denied an opportunity to be heard. Although my Rule 60B motion was filed pursuant to Rule 60B-4 and Rule 60B-6, and explicitly lists in detail all void orders and judgment on record that were implemented through collaborated conspiracy and perjurious filings of all allocated judges, see my Exhibit C, where I completely disregarded my evidence-based arguments, Chief Judge Norton consistently asserts that my arguments are without merit. More importantly, Chief Judge Norton's order failed to discuss or establish the validity of the disputed orders and judgment. while the case record confirmed that I am entitled to relief under Rule 60b-4 and Rule 60b-6, on page 7 of Chief Judge Norton's order, he forcefully states that a thorough review of the record leads to conclude that plaintiff is not entitled to relief. Chief Judge Norton's conclusion states that for reasons set forth above, plaintiff's motion for relief is denied. Contrarily, as evident by this order and the case record, this order is devoid of reasons. The substance of my Rule 60b motion, nor the disputed orders and judgment that generate the motion are disclosed. Chief Judge Norton's order forcefully states that plaintiff is attempting to raise the same arguments already addressed and disposed of by the Fourth Circuit and this court. Contrarily, the case record will confirm that the Fourth Circuit and the court in which Chief Judge Norton is affiliated failed to address and or refute any of my allegations. Exhibit H is District Judge C. Westinghouse's order denying my two motions to vacate his willful void orders and judgment. Exhibit C, D, and E. The first page of District Judge C. Westinghouse's order correctly states that the magistrate judge recommended dismissal of my claims against the 5 defendant judges based on judicial immunity. However, he failed to divulge the fact that he did not accept the magistrate judge's recommendation. Contrarily, as confirmed by the case record, particularly Judge House's order, my Exhibit C, he did not disclose or justify his dismissal of my meritorious claims against the 5 defendant judges named in my deprivation of rights civil action. On page 2, Judge House asserts that the plaintiff filed objections to the magistrate judge's reports and recommendations. However, the case records, as well as Judge House's orders, Exhibit C and D, both devoid of my evidence-based explicitly detailed objections, confirm his willful exclusion of my objections to the magistrate judge's reports and recommendations. Judge House also states that Chief Judge Norton issued an order denying my motion petition to recuse of the magistrate judge. I filed this motion subsequent to the magistrate judge's second purchase report and recommendation that is irrefutably established by the case record. Page 3 of Judge House's order states that when the plaintiff filed her complaint, she appropriately and explicitly voted the federal question jurisdiction of the court, pursuant to Title 28 United States Code Sections 1331 and 1343, and she cannot now argue that the court no longer has subject matter jurisdiction or somehow lost subject matter jurisdiction over her case. Contrarily, the case record will confirm that all orders and the judgment filed in this case are irrefutably based on the initial void order and judgment. See my exhibits A1 through A3 that initiated my deprivation of rights civil action. As confirmed by the case record, Judge House lost personal and subject matter jurisdiction over the case based on the following willful and malicious transgressions: filing of purchase orders and a judgment attempting to uphold known void orders and judgment, dismissal of my claims against the 5 defendant judges with no reasoning, dismissal of my deprivation of civil rights case without addressing my allegations and objections to the magistrate judge's reports and recommendations, failure to cite and address Title 42, Section 1983 and comply with its statutory procedure, violation and non-compliance with Rule 12b and other federal rules. The list of Judge House's willful indiscretions, see all exhibits, particularly my Exhibit C, Judge House's February 24, 2010 order, docket entry 37-1, that affirmatively substantiate the extent of Judge House's willful and malicious transgressions. Yet, Judge House falsely asserts that throughout all of his indiscretions, the court maintained personal and subject matter jurisdiction over the case. Contrary to all of Judge House's willful indiscretions and the fact that the case record affirmatively establishes that the orders and judgment upon which this case is founded were not adjudicated and his orders and judgment are based on these voids, he falsely states that my disagreement with his willful void order does not constitute a deprivation of my due process rights. Judge House is fully aware that this order, as confirmed by the case record, and his preceding orders and judgment are void as a matter of law and accordingly constitute a deprivation of my due process rights. Although a review of the case record will confirm that all of Judge House's orders and judgment based on unadjudicated voids brought to this court in a deprivation of rights civil action constitute willful and malicious fraud upon the court and deprivation of my due process rights, on page 4, he falsely states that the court found no basis for holding that its February order, docket entry 37-1, my Exhibit C, is void under Rule 60b-4. On page 5, Judge House states that the plaintiff's motion argues that all orders and judgments entered by the District Court and the Court of Appeals in her Title VII civil action that initiated her deprivation of civil rights civil action are void and must be vacated. He further states that I allege that the orders and judgments pursuant to deprivation of civil rights were procured by fraud upon the court, are inconsistent with due process, and are based on void orders and judgments. However, Judge House's order and all orders on record failed to acknowledge or address my supporting exhibits. More importantly, none of the orders on record proclaim that there is no evidence on record to support my allegations, or that my allegations are refuted by the case record. The order simply states plaintiff claims or plaintiff argues, cleverly circumventing what is established by the case record. A review of the case record will confirm that this order and all preceding orders on record failed to discuss or refute the substance of my explicitly detailed complaints and motions, inclusive of supporting exhibits that are cross-referenced to irrefutable evidence on record. The courts have continuously, willfully, and persistently failed to acknowledge the substance of my complaints, motion, and the validity or non-validity of the judge's orders that initiated my deprivation of civil rights case. In the last paragraph on page 5, Judge House states that the plaintiff cannot attempt to claim that the court lacks subject matter jurisdiction. Contrarily, the case record affirmatively establishes that Judge House lost subject matter jurisdiction over the case upon issuance of his first unsupported Prejudice Board order, dated February 24, 2010, docket entry 37-1, my Exhibit C. Although this court has a duty to vacate all void orders and judgments on record, Judge House opted to uphold prior void orders by issuing subsequent void orders in which he willfully demeans my integrity and denies my meritorious Rule 60b motions that he knows are wholly and affirmatively supported by the case record. Following are all void orders to date issued by the United States District Court for the Eastern District of Pennsylvania. This is District Judge Joe Slomsky's first void order, subsequent to District Judge Slomsky issuing this March 14, 2013 self-confirmed void order, denying my Rule 60b motion and dismissing my civil action with prejudice, without addressing my allegations, without adjudication of the disputed judgment, without applying Rule 60b to the allegation or disputed judgment, then contradictory within the same order, asserting that he did not have subject matter jurisdiction over my Rule 60b motion. I filed several Rule 60b motions petition the District Court of Eastern Pennsylvania to vacate this self-confirmed void order. To date, all of these motions has been denied. The second void order entered into the case record was filed by Chief Judge Patrice Tucker. This is Chief Judge Tucker's June 17, 2014 insufficient, unjustified void order denying my Rule 60b motion to vacate Judge Slomsky March 14, 2013 void order. The third void order entered into the case record was filed by District Judge Slomsky. On September 4, 2014, Judge Slomsky filed his second void order, another lengthy footnote, denying my Rule 60b motion to vacate his March 14, 2013 self-confirmed void order. In this order, Judge Slomsky purposely asserts that my prior Rule 60b motions filed with the South Carolina District Courts were denied on the merits. This allegation is affirmatively refuted by my evidential exhibits A through H, extracted from the corresponding case record. This perjurious footnote document falsely asserts that plaintiff alleged the same grounds for relief as discussed in plaintiff motion sent to Chief Judge Tucker. A review of all orders issued by the District Court of Eastern Pennsylvania will confirm that to date, all orders on file are devoid of discussions pursuant to grounds for relief set forth in my Rule 60b motions. The fourth void order, another lengthy footnote, entered into the case record was filed by District Judge Slomsky on November 24, 2014. In this order, Judge Slomsky once again denies my Rule 60b motion to vacate his March 14, 2013 self-confirmed void order. In the second paragraph, he asserts that the plaintiff sets forth the same grounds for relief as her previous two unsuccessful motions to vacate. Judge Slomsky also falsely asserts that the court properly denied my Rule 60b motion in March. This assertion is self-contradicted and affirmatively controverted by Judge Slomsky, March 14, 2013, self-confirmed Prejudice void order. In the third paragraph, Judge Slomsky willfully demeans my integrity by stating the court notes that should the plaintiff continue her pattern of repetitious frivolous filings, the court will consider enjoining her from filing without court permission. Contrarily, the only frivolous filings in the case record are the orders issued by District Judge Slomsky and Chief Judge Tucker. Yet, subsequent to depriving me of due process, Judge Slomsky now threatens to deny me access to the court. A review of my Rule 60B motion. See initial Rule 60B motion brief and supporting exhibits A1 through H. Will confirm Judge Slomsky willful deprivation of my due process right and willful fraud upon the court. The case record will also confirm Judge Slomsky willful repetitious entry of void orders into the record. The fifth void order, another lengthy footnote, entered into the case record, was filed by District Judge Slomsky on February 26, 2015. In the first paragraph of Judge Slomsky's fourth void order, he once again asserts plaintiff set forth the same grounds. However, this order nor any of his previous orders address the grounds set forth by the plaintiff. The unanswered question is, what are the grounds set forth by the plaintiff? In the last sentence of the second footnote paragraph, Judge Slomsky once again threatened to bar me from filing without permission if I continue to file the same motion. Contrarily, the case record will confirm that the substance of my previously filed Rule 60B motions were not addressed and accordingly not adjudicated. Therefore, I'm within my right to file repetitive motions until my motion allegations corresponding to Rule 60B are properly adjudicated under the provisions prescribed by the rule. This irrefutable void order, based on prior void orders, will confirm Judge Slomsky's willful deprivation of my due process rights, his willful fraud upon the court, and accordingly his loss of subject matter jurisdiction. Yet he continued to deny my meritorious Rule 60B motions to vacate his self-established void orders. Subsequent to this denial, on March 19, 2015, I resubmitted my Rule 60B motion to the District Court for Eastern Pennsylvania, addressed to the attention of Chief Judge Patricia Tucker. However, Judge Slomsky responded with the sixth void order entered into the record. Judge Slomsky is well aware that his March 14, 2013 self-authenticated void order showed the cause that affected my filing of rebuttal Rule 60B motions and judicial misconduct complaints. Yet on March 31, 2015, he filed his fifth void order, ordering me to appear in the District Court for Eastern Pennsylvania on April 10, 2015 to show cause. Judge Slomsky is aware that the cause has been pre-established and self-confirmed upon entry of his first void order. Upon entry of Judge Slomsky's March 14, 2013 first self-contradictory and accordingly self-authenticated void order, Judge Slomsky does not have the jurisdictional authority to schedule a hearing or to participate in any proceedings pursuant to this case. Therefore, on April 13, 2015, I forwarded my response to Chief Judge Patricia Tucker. My response explicitly showed in detail the cause as to why I should not be prohibited from filing whatever documents necessary in pursuit of the enforcement of my due process right. Subsequent to the District Court for Eastern Pennsylvania's refusal to vacate Judge Slomsky's March 14, 2013 void order, I filed several judicial misconduct complaints with the Office of the Circuit Executive for the Third Circuit. This is my first judicial misconduct complaint. This complaint distinctly and explicitly details District Judge Joe Slomsky's willful transgressions that are irrefutably substantiated by his March 14, 2013 self-confirmed void order. This complaint argued the fact that Judge Slomsky's order was devoid of acknowledgement and adjudication of orders and judgment upon which the Rule 60B motion was founded, although these documents were enclosed with my Rule 60B motion. This section also argued the fact that within this order, without application of Rule 60B, the rule under which the motion was filed, Judge Slomsky denied my Rule 60B motion, dismissed my civil action with prejudice, then asserted that he had no jurisdiction over the motion. Judge Slomsky's March 14, 2013 void order is self-authenticated, irrefutable evidence of willful judicial misconduct. Nevertheless, District Judge Joe Slomsky, Chief Judge Patricia Tucker of the District Court for Eastern Pennsylvania, and the Third Circuit Judicial Council willfully choose to disregard the nullity of this order, and in collaboration suppress my arguments and adamantly upholds this willful void order, by falsely alleging that my complaints, petitions, and motions pursuant to Judge Slomsky March 14, 2013 void order are frivolous and without merit. This is my record of judicial misconduct complaints filed against District Judge Joe Slomsky and judges of the Third Circuit Judicial Council who willfully filed perjurious void orders in an attempt to uphold Judge Slomsky March 14, 2013 self-authenticated void order. All complaints and corresponding petitions for review were dismissed, and subsequent to issuing of Judicial Council member Circuit Judge Thomas L. Ambrose's May 30, 2014 void order, he immediately filed an order to show cause to prevent docketing of a misconduct complaint citing his transgression and to prohibit me from filing additional misconduct complaints against fellow perpetrators on the Third Circuit's Judicial Council. Currently, the Third Circuit Judicial Council refuses to docket my meritorious complaints. However, due to the fact that my misconduct complaints are supported by the verifiable nullity of Judge Slomsky March 14, 2013 alleged order, I will continue to resubmit my complaints, petitions, and motions until the District Court for Eastern Pennsylvania and the Third Circuit's Judicial Council adjudicate my complaints and motions on the merit, and discontinue their filing of excessive and as substantiated by the corresponding case record, self-authenticated void orders, falsely asserting that my complaints and motions are unsupported and frivolous. This is the undocketed judicial misconduct complaint against Circuit Judge Thomas L. Ambrose. Pursuant to the filing of his first void order, Judge Ambrose was aware that a judicial misconduct complaint was forthcoming. Accordingly, he immediately filed a show cause order prohibiting the filing of this complaint detailing his transgressions. Then he proceeded to file additional void orders. Following is a partial list of judges, affiliated government entities, and associates who either infringed upon my constitutional rights or covered up the transgression of fellow perpetrators. All entries are based on location and position during time of interaction. Our American judicial system requires revamping, currently due to integrated corruption and collaborated cover-up amongst a vast number of judges, court officials, and alleged judicial accountability agencies. The majority of Americans' rights are oftentimes abused by our judicial system. Unless or until a United States government effectively monitors and enforces its constitutional responsibility to protect the rights and civil liberties of all Americans, its citizens will remain in a state of suppression implemented by the tyranny of nonchalant judges and other federal agencies who are historically unaccountable for their transgressions. It is obvious that our American government needs to devise and implement an effective accountability mechanism to protect and enforce the constitutional rights of its American citizens. A mechanism that is comparative to that imposed by its Internal Revenue Service, that diligently and effectively imposes and enforces tax liability and accountability upon all American citizens. Based on my experiences with our American judicial system, it needs several watchdogs with integrity to randomly select and audit the case files. My files from 2006 to the present will irrefutably and independently substantiate the collaborated corruption and cover within and amongst our American judicial system and other government agencies. No American citizen should be subjected to the demoralization and deprivations that I have endured over the past 9 years during my quest of my alleged guaranteed constitutional due process right. Accordingly, I implore our American government to act on behalf of all citizens and restore the reliance of the American people.
We shall overcome. Deep in my heart, I do believe